It is now my pleasure to kick things off with our first session and welcome back Stavros Gadinis, our moderator, as well as Chancellor McCormick, Vice Chancellor Glasscock, and Sarah Lightdale of Cooley.
Hello again from me. So our first panel is about the state of Delaware 2022 developments in Delaware law. And I'm very pleased to have Chancellor McCormick and Vice Chancellor Glasscock with us today. And Sarah will add the practitioner perspective and keep my professorial instincts in check throughout our conversation. And I'd like us to start with some of the most interesting aspects that came up in Delaware case law this year, and we'll start discussing the concept of director independence, especially in the context of MFW. This came up in a series of cases this year, and it's I think that Delaware case law is adding a lot of nuance and wealth into this concept. Think about it better. Something's happening with. Okay, well, I'll stay like that for the rest of the conversation. I'd like us, Sarah, why don't you kick us off and start us on the path of defining how we should understand director independence. How do these committees work? What is the appropriate conduct of directors in these committees, and what have we learned this year from Delaware?
Yeah, absolutely. And Chancellor, Vice Chancellor, one way that I would phrase the question on practitioners' minds here is that we sometimes see challenges to a special committee and the allegation that they're operating in a controlled mindset. How do we know what that looks like?
Well, look, I tend to approach this MFW context-specific, controlled or interested or non-independent director question from a very basic point of view, which is conflicted transactions raise agency problems, but we know they can be value enhancing. So the agency problem causes us to apply an entire fairness standard, but that's like a tax on a deal. And there are deals that won't happen if entire fairness is a standard. And so in a conflicted transaction, if you can remove the agency problem by having a majority of the minority provision, that can get you out from under entire fairness if that vote is uncoerced and informed. But in a controller situation, it can't really be an uncoerced vote by definition. So we have the MFW standard. And what MFW attempts to do is take away the control that the so-called controller can apply and put us in an arm's length situation. If that happens, then we can apply business judgment, avoid this deal tax. So that's kind of the basic framework of it. So if you're looking at whether a director on a committee is aligned with the controller, the question is, can that director be counted on? Is it reasonably conceivable at the motion to dismiss standard that director can apply business judgment rather than being within the ambit of the controller? If the answer is yes, then we could have, under the MFW framework, some understanding that this replicates an arm's length transaction, and we can allow it to move forward under business judgment. Otherwise, it simply stays under entire fairness. So I say that, I know it's super basic, but these questions of whether directors are truly independent comes up in context and under fact patterns. And so it's important to remember, are we talking about their liability? Are we talking about a 23.1 situation where they have to bring their business judgment to bear to sue the controller? Or are we under MFW? And under MFW, we're looking at all the facts that can influence a committee member to not be independent of the controller. And it really is just that simple. It's very fact specific. But we know that there are both social connections that can raise a conceivability, a reasonable conceivability that a committee member cannot be independent. There are financial reasons. Those are the things that we're looking at. So I don't know if that answers the question, but that's how I'd start it anyway.
Absolutely. Chancellor McCormick, would love to hear some more from you about the specific facts and circumstances that Vice Chancellor Glasscock was referring to that drive the analysis.
Sure. Well, I think he nailed the big picture, which is that we're trying to permit value-enhancing transactions while policing for conflicts, and these committees we form are for that purpose. I thought actually what I might do is kind of pull from specifics of a few recent cases to try to put this analysis that we so frequently encounter in context. And I'll start by saying procedurally we encounter the question of conflicts at the committee level in multiple different ways. In the 12b6 scenario, we're looking at what's reasonably conceivable. The Rule 23.1 scenario, we're looking at what we can discern from particularly alleged facts. At summary judgment, we're looking at whether this can be resolved, material without, any dispute over material facts. And then at the end of the case, we look at what's proven. And these, that dramatically dictates the outcome of whatever decision is before us, the pleading standard, or the relevant standard of review, unsurprising. All right, so there are three things I wanted to draw out. The first is a recent case by Vice Chancellor Zern called Match Group, where she grappled with the question of, when we're looking at a committee, how do we assess the independence of a group, right? And in that case, she dropped a footnote, I think it was footnote 142, that really drilled into this issue and wrestled with an area of ambiguity I injected into our law in a prior minute order, effectively, or speaking order, resolving a case. And the question was, when you have a group, is it enough to say that a single member of that group lacked independence or somehow infected the process, or must you look at the group as a whole? Must the entire group be affected? Or is there something in between, like a majority or a simple or a majority of the group? And she canvassed case law and articulated it as follows, and I paraphrase, that when you're assessing the independence of a group, we're looking to see whether at least 50 members were affected negatively by conflicts, or 50% of the members were affected negatively by conflicts, or whether a single member dominated or infected the process. Now, a lot of attention has been given to the dominated or affected standard, or infected, and particularly to the dominated factor and the role of a chair in that analysis. And although I don't have any specific guidance for you on that factor, I will say not to ignore the broader language, infected. For example, you can imagine a scenario where back channeling through a special committee process somehow detriments the process as a whole. And so we are looking at the bigger picture. Anyway, so that's the first issue is Delaware courts are actively grappling with the question of how to assess the independence of a group of people. The second factor I wanted to draw out is, independence isn't just a gating issue. And I want to speak specifically to Rule 23.1. Rule 23.1 is a procedural rule, but it is the procedural embodiment of a substantive aspect of Delaware law. And as Chancellor Bouchard and Vice Chancellor Will's BGC case reflects, the question of whether the board was sufficiently uncompromised to independently and disinterestedly assess the demand to pursue litigation is one that, as a consequence of being a substantive rule, can arise at many stages in the litigation. Most frequently at the pleading stage, but also in the case of BGC at the summary judgment stage. It's dramatically inefficient for a court to have to assess this multiple times. And at the pleading stage, we look at whether particularized facts support the inferences, and later on we look at whether facts have been proven and what the record reflects. I don't know that we should view it this way. I don't know that this is the best way for Delaware law to go, and perhaps we should view it as a gating issue. But when she encountered this, Vice Chancellor Will faithfully applied our law and concluded that it was substantive and could be addressed multiple times. It's the second issue. And the third issue, Sarah, is one that you raised, and that's how we assess situations where the relative wealth of board members matters. Some of you have heard me speak about this issue before, and I flagged it in a decision I wrote in Brookfield. But here's the issue. When we assess the independence of directors, we look, among other things, to their financial benefits they gain from the transaction or the board service generally. And one of those financial considerations is the fees those directors are paid. And we want to look to whether serving on this board matters to the directors such that they'd place interest in continued board service, which could be generated by pleasing a controller, over doing what's best for the company or the stockholders in connection with a particular transaction. And so in theory, if you extrapolate out kind of our focus on financial interests, we could have a situation where a director of limited means might view the director fee more material than a director of considerable means. At least some of our case law suggests that this is what the materiality analysis calls for at the pleading stage. I caution against that interpretation for a lot of reasons. First of all, I think it rests on a faulty premise that poor people are less likely to be independent and make good decisions, and that relative wealth should matter. Secondly, it invites a level of sleuthing at the pleading stage on the part of plaintiffs' counsel that they probably feel uncomfortable with, and certainly we do. We don't necessarily want people to go into nominally independent directors, financial statements or personal lives or have personal investigators following them. That's not what we're trying to incentivize. And thirdly, I worry that posing kind of this relative wealth analysis at the pleading stage creates disincentives for boards to diversify. We all know that underrepresented persons, statistically, and in society, make less money than others. And at a time when we're trying to encourage boards to value multiple perspectives, and for society as a whole to do that, I worry that the relative wealth analysis at the pleading stage could impede that. And so I'm in favor of more of a bright line rule where if the director fee is not oversized, not facially problematic, and certainly we have tons of literature on what the relative standard of a director's fee is based on peers and the like, that we stop the analysis there and assume that standing alone is not likely to generate conflicts. That's not necessarily our law. That's perhaps where it's going, but those are my thoughts. So thank you for asking.
And can I comment on a couple of things? This is a very interesting issue, and all these gating questions are an attempt to call out frivolous cases and keep in meritorious cases. It's obvious, but that's what we're doing. And the question is, what is our tolerance for losing some meritorious cases while we're doing this culling? And that's the whole reason behind this motion to dismiss level analysis. The question of the group versus majority versus all of a group versus individual sufficiency to find that an action of a committee is independent is a fascinating one to me. And our case law is not developed, not gelled. But one of the things I'm always looking for, and it's difficult at the pleading stage, is did this committee operate like a democracy in some sense? I mean, were they all involved in the decision?
In a healthy democracy.
Yeah, well, yeah. I mean, I'm going to keep my mouth shut and just go forward with my thought, which is, or is it kind of an autocracy, particularly where the chair of the committee is the one who has the conflict? That's very problematic because just a basic level understanding of how group dynamics works makes me suspicious if you've got a chair who is calling a lot of shots, maybe a minority and the other 2 or 3 members may be completely independent, but it's a very difficult question at the pleading stage. But that's the kind of thing I'm looking for.
So an example would be the chair for leading the choice for a financial advisor or for a legal advisor.
That's a perfect example. So if that's dictated from the chair, if the chair says, hey, I've gone out and hired a financial advisor, here they are, they'll be coming to present to us, that's a lot different from a discussion of who should we get and what are the considerations. And there are a number of decisions like that that have to be made throughout the process. And to the extent in a pleading, a plaintiff can make the case that those decisions were disproportionately being made by a chair who has a conflict. That's a much likelier scenario for a minority conflict to nonetheless lead to a denial of independence for the committee's proposition that it comes up with.
So the significance of the pleading stage analysis comes through, and I want to address it from a practitioner's perspective for what these complaints look like. Many MFW complaints are brought, of course, after a Section 220 demand and Section 220 production. So it's come to feel inevitable that the complaint will quote a number of documents, won't attach them, the defendants will respond with a raft of documents, and the court will be left to sort it out. How should practitioners approach the use of documents outside the complaint in a way that's useful to the court at the pleading stage in these cases?
Sam, I know you have strong views on this.
Go.
Well, this is not an easy question to answer. It's shockingly so. It should be more straightforward, and we grapple with it on a case-by-case basis. The purpose of allowing defendants to bring into, documents produced in 220 is to make sure that, the plaintiffs aren't cherry-picking information and that the record that the plaintiffs were drawing from is fully before the court. At the same time, there's an over-reliance on those documents to the extent defendants pull, minutes or other information sent to the plaintiffs and present it to the court as if the statement on the page is true. And so, or seek the court, ask the court to draw a defendant-friendly inference from that statement. That's crossing the line. It's not what we're trying to create. It's not the system of rules we're incentivizing by permitting use of these documents at the pleading stage. Easier said in theory than in practice. I mean, it's always a balance, so I have no good answer for you right now.
The imposition of a production of documents on a condition that they be incorporated in any complaint. This is a 220 production and then a subsequent complaint. The idea of the court imposing that condition is, as the Chancellor says, to prevent cherry picking by the plaintiff. The plaintiff's bar, and I think they've got a point, will tell you, well, yeah, there's somebody picking cherries, but it's not us. It's the company when it decides what documents to produce. And what we can't have, and must be careful as a court not to have, is a battle of facts based on documents at a motion to dismiss stage. It's not good for the process. You don't get a just result. And so we have to be judicious about to what extent we'll allow defendants to produce documents in rebuttal. To me, if there is one document that rebuts a core presumption, and a defendant can say, wait a minute, the plaintiff fundamentally misunderstands what has happened here. Here it is. That's one thing. But just, well, look, we've got all these other documents that draw a very strong inference against the plaintiff. That's not what a motion to dismiss is for. And so we've got to be very careful not to turn a 12b6 standard motion to dismiss before discovery starts into a quasi-evidentiary hearing or process.
I totally agree. I mean, it's kind of interesting to trace the origin of the incorporation by reference condition because it was first, given its judicial imprimatur in the Yahoo case. I was a litigator. It was the only thing we won. And it was intended both to prevent cherry picking and to incentivize companies to produce records short of litigation, if they have this benefit at the pleading stage in a follow-on lawsuit. It rapidly, revealed its problems, and Vice Chancellor Glasscock attempted to address kind of cherry picking by the defense side through what was the case where you required them to certify the completeness of a production?
Yeah, I can't remember the name.
Like, attorney, sign your name, certifying that this is not a cherry pick production, is how I interpret it, the decision. And we've kind of gone from there. Now, having, this victory on the page of this incorporation by reference condition, I'm regretting it because as a judge, I get just 60 documents attached to a pleading stage motion. It becomes quite difficult. So it's definitely something that we're trying to wrestle with. So.
But with all due respect, that's not the origin of this.
Oh yes, Morton's.
Well, this is where I think it started.
He has a longer memory than me.
Well, I've been around a lot longer, but I wrote a case where the condition that was sought to be applied was not the incorporation by reference provision, but a venue limiting provision, that these documents can be used only to bring litigation in Delaware, not in any other jurisdiction. I looked at that and said, that's easy, you can't do that because I can read the statute and there's nothing about the statute that says if you're entitled to these documents, nonetheless the company can attach some kind of condition to it. And the Chief Justice reminded me that I had that discretion and suggested in the strongest possible terms that I should apply that discretion in a meaningful way. And so sent it back to me. That's what I think is the beginning of attaching these conditions goes to.
It's interesting.
All right.
So I wanted to ask, once we abandon the MFW framework, for example, because the vote from the minority hasn't happened, we are in the entire fairness world, which you've described so well before. But of course, fair process is also part of entire fairness. So the special committee and the operation of the special committee in that context is also relevant. So I was wondering if you could tell us how this concept of fair process works outside the MFW framework. Are there any differences that we need to be aware of? Is it similar to the conversation we've had so far?
Well, look, if MFW doesn't apply, we're just back to our standard jurisprudence as it existed a few years ago. And that is that the burden is, unless it's been shifted by some other procedural device, on the defendants to show that the conflicted transaction was entirely fair to the company and the minority. And that's our courts have come up with this almost Jesuitical formulation of, it's a
I don't know what that means.
It's a two-part.
I would say it's Catholic.
It's a two-part analysis, but it's unified. That's why I've struggled with that ever since I first heard it, and I do think it's somewhat related to some of the concepts that. Anyway, the two-part analysis unified to me means that a fair process is a tool to discover fair price. And a fair price is typically revealed by a review of a process, and if it proves to have been a fair process, it's indicative that the price is also fair. That's why the use of independent committees is extremely important if your task as representing a company that's engaged in a transaction is to show that the transaction was entirely fair. It's a continuum from simply an imposed price by a controller all the way to MFW. Somewhere in the middle, if you're not under MFW, you're going to have to, if you're representing that transaction, if you're advocating for the fairness of that transaction, you're going to have to show what the review was that made it fair. If you've got an independent committee, even if it doesn't qualify MFW, it's not empowered ab initio. But if there's an arm's length negotiation by a committee, that goes a long way toward indicating to the court that there's a fair process. And you don't have to have a fair process to get a fair price. I mean, you could have a deal where a controller imposed on the control board that it would have to accept a price that was going to be set by tomorrow's pick 6 number, right? And you get a huge pick 6 number, the deal goes through and the company's been overcompensated. It's possible, and in that case it's still a breach of fiduciary duty, right? there are no damages, but it's a breach of duty. But really, without an adequate process, the more bare bones the process is. For instance, if the company just goes out and hires a financial advisor, the controller, and the financial advisor comes up with a number, and there's no committee to ratify it, there's no vote of the minority to ratify it, that action by the advisor and the information given to the advisor becomes of paramount importance. And you're placing an awful lot of weight on a slender reed if you're relying on that to demonstrate to a court that the transaction was fair. So once again, the more you can replicate an arm's length transaction, the more likely you're going to be able to show the court that a transaction had a fair process, and the more likely is that the court is going to find that process resulted in a fair price. Sorry about the Jesuitical reference.
No, I liked it.
Well, I'm going to turn us to talking about Caremark, everybody's favorite topic. So, Vice Chancellor Glasscock, you observed in the SolarWinds case this year that post-Marchand, Caremark claims have bloomed like dandelions after a warm spring rain. So we're hoping that you can tell us what you've seen in that field of dandelions this year.
Well, look, it is one of the wonderful things about, and there are many of them, about getting to be a vice chancellor on a court of chancery is you see how creative attorneys are at this level in finding, the slightest.
Is that the word?
Speaking of dandelions, finding the slightest crack from which to sprout and seek the sun. And it works for defense counsel as well, right? So there's a tool. Marchand was a tool. And it's been attempted to be used as a pry bar and a sledgehammer and a jackhammer and all kinds of ways. Basically, however, I think Caremark ultimately remains the same. We were talking earlier about whether we should even fetishize Caremark as something special outside of the rest of corporate law. It's not. It's a breach of the duty of loyalty action. And it's a case where the actions of directors, if they appear so inimical to the interests of the company that they must be the result of bad faith or scienter, sustain a breach of loyalty cause of action. So Marchand was kind of a roadmap, and it has been creatively adapted. I don't know that there should be any real concern about a wholesale expansion of Caremark doctrine. As I say, it really is a duty of loyalty action that is addressed to a specific kind of board consideration, and that's risk to the company.
But despite the poetic image of the dandelion field, I'm sure there are a lot of people in this room that are anxious about the implications of Marchand and Caremark and about the discussions in boardrooms or in committees about mission-critical issues. And I was wondering if you could give us some idea about what you would think would be an appropriate way of discussing critical issues. How do we have to have a committee about each issue, or does it have to be named in the committee's charter, for example? Does there have to be, how many discussions should they discuss it, for how long, how many? I'm sure there are, I'm pretty positive you're not going to give us minutes of discussion, but I was wondering if you could tell us, if you could give us some indication about how a proper conversation about an issue would look like.
Sure. Could you do one thing for me? Define mission critical.
Oh, please. I should do that?
I was hoping. I'm waiting for somebody to do it.
We'd all like Chancellor McCormick.
Do you want to take this? You want me?
You have a great, I think that your advice to board members is great advice, Sam, if you want to lay down the bottom line.
Yeah, the bottom line is this. If you're making a good faith effort to fulfill a duty of care as a director, you shouldn't have to worry about Caremark, because it's a much higher burden, right? It requires a pleading of scienter. And so I think that's the lens that the board ought to be operating through. mission critical is one of those shorthands that really doesn't convey a great deal. I had the GM ignition case several years ago. Was a horrible fact pattern, right? The GM was producing cars. At some level, its engineers knew that its ignition switches were cutting out. There was some question about to what extent that ever got above the engineer level. But the results were horrific because on a modern car, your ignition goes out, you can't steer, you can't brake. People were dying. So is the ignition switch on a passenger automobile mission critical? I don't know. You don't need an ignition switch committee. I mean, you can't have a committee for everything. The point is, does the board have a system where, particularly with critical safety issues in a heavily regulated industry, do they have a system to get that to where they can review it? And if they do, are they in some way, in a blatant fashion, so ignoring the information they're getting that a court who has to review this is going to scratch its head and say, I can't see why they would do that other than the fact that they're just acting in bad faith. So it's a very high standard. And the other thing about Caremark, to me, that is critical to remember as a judge, is the victim, the plaintiff in a Caremark action, is the corporation and its stockholders. Sometimes the very people who've benefited inadvertently from the bad acts of the directors. It's not the victims. It wasn't the victims driving Chevrolet Impalas that lost their steering who were seeking recovery in the GM case. So often these cases are heart-tugging, but we've got to remember, first of all, is it a value-enhancing thing to try to hold directors liable in a case where they may or may not have had direct understanding or should have had direct understanding of a problem? And second, are we really addressing the problem that regulation or statutorily should be addressed? And we may talk about that, I guess, if we talk about some of the expansion ideas for ESG.
Yeah, I mean, well, so Chancellor McCormick would love to hear more about the concept of mission critical. It seems that mission critical often overlaps, but maybe not always, with risks that are heavily regulated, that the company is well aware of, the government is well aware of, but we're not always in that space. And so I'd love to hear your thoughts on the extent to which positive law is critical to the Caremark analysis.
I think that's a great question. Before I turn directly to that, I wanted to react to one thing. I do think that Caremark has force as soft law in the boardroom. I think we all believe that. And so when you're hearing Vice Chancellor Glasscock say, if the board does this, then they shouldn't worry, the emphasis should be on the if part, and not on the then. I mean, you tell my 16-year-old daughter that, if she studies for the test, not to worry, it shouldn't be too hard, then she's just going to put her pencil down and not worry about it. All she hears is not worry about it. And so there is a bottom line requirement of Caremark. There is something we encourage boards to do. And the phrase mission critical is vague by design, and that's because each company is different. What constitutes critical risk for each business model is going to vary. And we want all boards to reflect on what that means for them, right? So your question was whether mission critical is fully, if the Venn diagram of what constitutes mission critical fully aligns with positive law. I do not believe that it does. I think that the refocus on mission critical by Marchand allowed Delaware to inch away from a world where Caremark only policed a board's focus on positive law and regulatory risks, or the possibility of tort claims. I think we're slightly beyond that. Now, that's not to worry for the defense attorneys in the room, because I don't believe there are many fact patterns where what constitutes mission critical risk is actually an unregulated group of activities, at least not in this country. And so, this is a theoretical conversation we can all have, and certainly we can think of examples of how it applies. But in practice, regulations typically flag what should be of concern for a corporation. So.
And I would add to that, it is certainly theoretically possible to come up with a scenario that would surely satisfy a bad faith standard where a board is consciously ignoring business risk in a way that not only harms the corporation financially, but harms its reputation. And it's not hard to come up with a scenario. It's just hard to find a fact pattern in real life that will fit that scenario. Yeah. So I don't expect it to become a common thing. But there's no reason that the theoretical framework of Caremark excludes non-regulatory, non-statutory violations. Once again, it's merely a duty of loyalty claim. It's a bad faith claim, and a board that whose directors acts in bad faith can be liable for a failure to oversee corporate functions, regardless of whether it comes up in a regulatory or statutory context.
We did discuss cyber attacks as an example of an area where something like this might happen, and I was wondering about that. And also in your remarks, you also mentioned ESG as a particular as another source of potential claims. So nothing like that has happened, as far as I'm aware. So I was wondering if you could expand on that a little bit.
Well, sure. Yeah, and I think they're really two different. Those are two interesting and different questions. So. There have been a couple of cases now. I'm not going to talk about mine. It's on appeal. But so I better just keep
what you think.
I'm just going to keep my mouth shut about that. But look, cybercrime is an interesting hybrid because typically, we're talking about boards ignoring risk. We're talking about them ignoring risks that the company is breaking the law. This is a situation where the board is accused of ignoring risks that some third party will injure the corporation and its customers. It is creeping, or maybe galloping, toward regulation in any event, I think. Some of the stock exchanges are imposing requirements. It's getting to where it will be, perhaps in a few years, a more traditional Caremark analysis if there's a failure to assess this risk. So that's really all I have to say about that. As far as ESG, I think this is my personal opinion, not the court's opinion, not the state of Delaware's opinion.
All of this is our personal opinions.
But I think it's a very clumsy tool to try to enforce social justice. Surely the board has the right to expend corporate capital in pursuit of ESG goals. That's a separate issue, but to try to use oversight responsibilities to impose social responsibility on the board, I think is a very difficult proposition, and I don't that we're even talking about it, to me, speaks of a regulatory and statutory failure to address fundamental problems, and to rely on a court assessing the actions of corporate directors to do that seems to me unlikely to be successful.
All right.
Yeah, perfect.
So I would then bring us to talk about the state of Section 220 in the state of Delaware. Chancellor McCormick, obviously, from your vantage point as the head of the court, you've got the bird's eye view. What are we seeing in terms of trends of Section 220 cases that are reaching the court, and then beyond that, those that are going to trial?
Right, so talk about dandelions. I mean, Section 220 actions have dramatically proliferated over the course of the past 5 years. And there are, in my view, two causes for that. The first is that we've now said that this is an appropriate way to investigate potential fiduciary misconduct in the deal context. And so part of what we're seeing are an increase in Section 220 actions seeking to investigate wrongdoing in connection with deals. That's actually not the majority of what's driving the increase in 220, but it's part of why we're seeing more lawsuits. The second cause is that Caremark has been viewed as a more muscular theory post-Marchand. And when other avenues for plaintiffs' work have effectively been closed by doctrinal transformation, we've seen people move their focus to Caremark claims. And it's as if the world of litigants awoke after 30 years of telling them to use the tools at hand to investigate these claims. They said, you know what we're going to do? We're going to use those tools at hand. We're going to send a 220 demand. We're going to seek to investigate it, and if they don't give us the documents, we're going to file a lawsuit. So I feel like those two kind of phenomenon are driving the increase in cases on our docket. And just to put in perspective, I mean, we now have enough 220 actions to fill an entire judge's docket. There are not that many of us.
Don't look at me.
I will say that since Vice Chancellor last year's AmerisourceBergen case and my Gilead decision, many more of these Section 220 actions are settling out before they go to trial, or the number of issues being litigated in these cases is reduced dramatically. So we've seen some efficiencies in recent months and in this past year in that area of law.
And could I add one other factor that's driving this increase, I think, is the increased use of the ratification of both a majority of the minority vote or the whole MFW framework makes a granular understanding of what the boards and committees have done important at the pleading stage. Mm-hmm. So that's just one more thing. It takes a lot of guts for a judge to do what the Chancellor did and what the Vice Chancellor did in AmerisourceBergen, and use in an appropriate but muscular fashion the bully pulpit of the court and the potential for taking some type of sanctions action to instruct the bar that the particular lines of defense were getting suboptimal, inefficient, not just for the court, but for litigants. And I think those two cases have, more than anything else, made the system operate where it ought to be operating, which is on the scope of documents in most cases, and not on the other defenses that are available. Of course, if they're real defenses, we want them brought out. But what we don't want is too much litigation when really what we're talking about are core documents being produced. If it's beyond that, then that's where we're getting a lot of litigation.
Right, and I do think that that's where the work of a defense attorney really lies, and their sights should be focused.
So one common theme that we've seen arise in a few different cases this year in terms of the categories of documents that are produced in Section 220 demands that have implications are corporate minutes or board minutes and committee minutes. And we've seen in a few different cases, Sharp Spring and NiSource Goldstein v. Denner, that minutes sometimes are insufficient or inadequate, or maybe they're even inaccurate, and those can create enormous headaches. What can we do better before we produce the minutes that create all these headaches to make them less problematic?
I would say, by now it's a trope. Like, contemporaneously prepared long-form minutes are what we as a court encourage companies to prepare. We recognize that they're not always going to be perfect or complete, but as long as you make an effort, that's a great defense to an intrusive scope of inspection in response to any 220. It's not just best practice. It's not just a good idea. The idea of these minutes is actually to record board decisions. But it's also a great defense in the context of 220 to a more intrusive scope of inspection. So if a company produces long-form minutes, they seem to be robust. Often, a stockholder pursuing 220 inspection will walk away and move on to the next step of his or her action. Sometimes they will view the minutes as an incomplete record of what occurred, either by comparing it against the proxy or other information, and seek other additional documents, and we will look at those narrow requests and try to circumscribe them to a targeted scope of inspection. And I think that's the incentive we're trying to create. That, I think, is what's happening. And occasionally plaintiffs do get a foothold where the minutes are clearly inaccurate or incomplete or inconsistent with the proxy. Those circumstances are fairly rare. They might look like they happen more frequently than not because when we write decisions, that's what we focus on. But in the world of what you all are seeing, the practitioners in the room, particularly the defense practitioners, I think you're seeing a lot more 220 demands, a lot more that are resolved short of litigation, a lot more that are resolved shortly after litigation is filed, and very few that actually go forward with the scope analysis before the court.
And as the Chancellor pointed out with Caremark, this is another case where good practice is also good defense, right? We hope that's always the case. That's because that's the purpose of the law is to encourage good practice and only get involved when there is something that is unfair to the stockholders. So it's a particularized analysis because it depends on the issues that the stockholder is seeking information about. But I would agree, you're unlikely to be able to get more personal communications if you've got a long form set of minutes and there's no glaring inconsistency. I mean, that's the other thing.
So we're almost out of time.
yeah.
So I was wondering if we could talk about an issue that we discussed briefly, which is the media attention to the court this year. And so how do you feel about all this that's happening?
I personally feel exhausted. Yeah, I mean, Delaware courts, and our court in particular, is always subject to, media scrutiny. We always, it's a matter of public interest. A lot of what we do is relevant to the world. Delaware plays an outside role, and that comes with, the attendant attention that sometimes makes people like us feel uncomfortable, but is simply necessary. And that's something we all knew when we signed up for this job. It ramped up very intensely this past year, and so all of the, the importance of it and kind of the corresponding insecurities for being a jurist similarly enhanced. But I will say that I hope our handling of matters this past year has underscored a few things. First of all, that our court's deeply committed to public access. And it's hard sometimes. I mean, we are a staff of 75 humans throughout the entire state of Delaware. We deal with an incredible amount of work, not just in the corporate sphere, but also guardianship petitions that affect real people's lives in the state of Delaware. It's a lot of work. We're already a very lean ship. So when you have hundreds of members of the public calling about a particular case, it really strains our ability to kind of administer other aspects of justice. So we try to get out in front of those situations and create moments for public access lines, publish our decisions in a way that they can be accessible. That's the first takeaway. The second takeaway is, what the Academy does and what members of the press do and what kind of these informal news outlets do to take our complex decisions, break them down into digestible, bite-sized messages for the public that's interested in our case. It's truly remarkable. It's a service to us. I think it aids in our ability to convey the rule of law to people who are interested in learning it and elevates the public dialogue. So, shout out to the Chancery Daily, shout out to Professor Lipton, who's done a lot of live tweeting. Great job. I mean, as uncomfortable it is for me to know what my clerks are telling me everyone is saying the instant I publish something, word by word, page by page. I mean, it's a service, and I'm grateful for it.
Well, thank you very much, and we'll be glad. Thank you very much. It's been a pleasure.